more discussion. Thank you.
First of all, congratulations coming in under time. I appreciate that. And I just had one additional thought just in the minute or so you have left.
Sure.
The question of who is in the protest, does that change what kind of social media they would have access to? Because it strikes me that many protests, including the convoy one, would have a variety of people, truckers, perhaps extremist groups, others. And does it make a difference who makes up the protest in terms of what kind of social media they're likely to use? And that's a big question. So if you want to pass to the other panelists at some point, you're welcome to do that too.
Sure, I can be very brief and then we can pass it along. I think perhaps a way to understand it is to think about it as layers. So some social media sites are more public facing than others. For instance, a Twitter or a Facebook or an Instagram, it is very public facing. It is about publicizing very broadly a specific message or an idea or a concept or an argument. But there are other layers of communication within different social media sites where you might have different levels of encryption so that monitoring or surveilling is a bit more difficult. Only the participants can see the end-to-end of that communication method. And so that more, not necessarily surreptitious, but closely guarded form of communication or information sharing, I think forms different layers. So you have a more public-facing layer, which is garnering support in memorializing, in conveying details that are comfortable to be shared publicly. And then you have more subsequent layers that are perhaps more closely guarded.
Individual users that are posting the particular information. And we do have a variety of laws that, that target false information, but we do not have any law in Canada that broadly addresses or targets mis and disinformation, at least the way that we're contemplating here. So we have the crime of spreading false news, but that was held to be unconstitutional in the case of Zundel. And other crimes that target false information would be crimes of hate propaganda, counseling terrorism, fraud. And in civil law, and Jonathan touched on a few of these, defamation. Defamation is where, you know, someone sues another individual or entity for spreading false information that impacts their reputation. And perhaps also, I would put in here the tort of false light. So that has just been introduced or adopted in Ontario. So it's just sort of a hodgepodge mix of different laws that apply to some aspects of mis and disinformation. One of the issues is that a great swath of this is what I call lawful but awful expression. It's hateful but not hate speech. It's extremist content. But it is not counseling terrorism. So it's not unlawful in the traditional sense. And also, as we were just talking about, the role of social media and pushing, you know, through advertising and recommender systems, it might be that lawful but hateful content ends up being pushed to users over and over. So in law, these are difficult areas to deal with. Under constitutional law, we have the right to freedom of expression. It is a broad right. It includes the right to seek, receive, and impart information and ideas. It includes the right to shock, offend, and disturb. And it also values false expression, in particular if it's information that's of public interest. So restrictions of it are supposed to be narrowly construed. And we face a hurdle in this area because what is truth, right? What is the perception of truth in one particular scenario? And I've listed a few laws where courts have willingly, you know, addressed what
to collect a lot of information upstream from the protest movement and on the objectives, and it will allow us to know whether certain extremist groups talk about recreating 6th of January in Ottawa, as we saw in the Capitol in Washington, and it will allow us to know whether we are talking about the obligation to vaccinate people, or is it to block Ottawa and overthrow the government? So the social media gives us some visibility about the causes of the movement if information is well collected and well analyzed. Now, in the context of the movement itself, social media create some volatility. And Wayne, you asked a question earlier that what we saw with Ottawa was that there were a lot of people from very different political horizons who came to participate in this demonstration. People came with their children, their families, who were really challenging the sanitary measures, and others who had more extremist political agendas. And the social media allow this. They are like a menu in a restaurant. They put out all kinds of ideas online, and then individuals can appropriate some ideas and make their own menu out of that and participate in a common cause according to the various ideologies that are covered there. So the question of managing this crisis, there is some volatility because of the social media, because if the social media says we're 100,000 people in Ottawa, it's certain that that can create a snowball effect. So disinformation can have an impact. Dax mentioned this on operations, can use encrypted messaging to give each other messages about where we are, etc., to coordinate things. So it does have an impact on the management of these crises, and I think it's important to mention that. The second point on the question of regulations, and I'd like leave my colleagues to express themselves on that. But when these emergency measures were created 30 years ago, there was no social media at the time. And we're talking about a law here, talking about security, where social media didn't exist. That's what we had. And if, for example, in a demonstration where you may have some violence happening, and I'm being careful here not to surpass my objectives here, but in the context of an emergency law, if we're in a volatile, unstable environment, we can use law on emergency measures in a preventive way. For example, if a province, and I can make a parallel with for example, an extreme climate crisis may...
Conversation here, Professor Chandra, because the Ambassador Bridge is critical to the discussion here at the Commission, obviously played an important role in the events that gave rise to this Commission. And we know that the bridge was blocked for a period during the events that took place. So I'm wondering here if you can, tell us a bit more of the backstory. How is it that Canada and Ontario became so dependent on the Ambassador Bridge as a trade corridor?
So as best as I can tell based on my research, a lot of this has to do with what I would call historical accident and then path dependence. So the Ambassador Bridge was built almost a century ago. It was completed in 1929. It was built to facilitate trade across the Detroit River between Michigan and Ontario. And once it was completed, it was used heavily by the auto industry because Ford and General Motors and other car manufacturers had plants in both Michigan and Ontario. And so they relied on the bridge extensively, going back to the 1930s and since then. And the trade over the bridge became so important commercially and economically that we saw a lot of investment made to support the bridge. Investments were made both by the private sector as well as by governments. So the private sector, the firms that traded invested by building, warehouses, sorting facilities, loading docks, in order to, quickly and efficiently transport goods that were coming on and off the bridge. Governments invested by, building highway on-ramps and off-ramps. So Ontario 401, Interstate 75 and 96 in the US, all of these interstates point directly at the Ambassador Bridge. Governments also invested by allocating customs agents, building customs inspections facilities, and so on. And so the more investment that the bridge attracted, the more efficient it became to process vehicles. And so the more traffic it actually attracted, including by non-auto industry actors. And so we sort of got into this cycle, which you can think of as either virtuous or a vicious cycle, by which it attracted more traffic, so we threw more infrastructure investment at the bridge and so on. And so now the Ambassador Bridge is absolutely vital to Canada-US trade, carrying 30% of our trade. And it's not as though it's all the auto industry. So like I said, Ontario gets about 63% of trade with the US. You might think that that's dominated by the auto industry, but it's actually not. By my calculations, even the non-auto industry, so everything other than automobiles, is still heavily concentrated in Ontario. A little bit less, more like 55%. But that just goes to show you how even other industries became reliant on the Ambassador Bridge over time.
Okay, thank you, Professor Chandra. I'd like to invite those who are on the screen with us to contribute to this discussion. Monsieur Delorme, Madame Houlette, Professor Quigley, would you like to add anything at this moment about the significance of the Ambassador Bridge as a trade corridor?
Yes. I just wanted to say that as we summarize in dollar amounts what Madame Ouellette has just explained in learned terms, it's anywhere from $150 to $400 million in lost costs, lost income, trade income. So there's a very real economic consequence for Canada. Thank you.
I see that your hand is up. Would you like to add something here?
Sure, I'll just add a couple of terms I think that are useful in terms of thinking about risk problems that can maybe complicate or simplify things for us a little bit. I think one is we often talk about resilience in this field. The term gets used a lot. I feel it's probably losing a little bit of traction just because it gets used all the time to describe a whole bunch of different things. I think it has many, many definitions. But usually when we talk about resilience, we're talking about some sort of adaptive capacity or flexibility or some capacity to bounce back after a failure. That's really important, some capacity to bounce back either through some sort of technical means or organic means. But I'm not really sure that fully satisfies the discussion today. So there are a couple other terms that I think are worth thinking about. One is the concept of redundancy. So when we're thinking about managing risks, the question is, do we have redundant systems in place? So we might think about multiple bridges rather than one bridge. So if we're thinking that when we think about redundant systems, it's the concept of having another system in place that can help us to achieve the same goal if the first system fails. Now that's an expensive way to manage risk, but nevertheless, that can be important if you have a critical system in place. So do we have some redundancy in place that can manage to step in, let's say, if the first system fails? And the second concept is the concept of robustness in our infrastructure. And so when we're thinking about robustness, and I'm referring particularly to the International Risk Governance Council framework, when they talk about robustness, they're talking about systems for which there isn't necessarily redundancy, for which there isn't necessarily resilience. And therefore, we have to make a special effort to protect that infrastructure or to make that infrastructure strong, because if it fails, there will be massive consequences, cascading effects to the failure. So I think this concept of redundancy and robustness can be helpful for us today.
Great. I might come back to Professor Chandra to ask you just a bit about how these concepts are relevant in the context of the trucking industry and
Public Safety Canada. So this is already very much on their radar. It's also worth noting some newer developments in the field of critical infrastructure protection that have happened over the last couple of years. In the summer of this year, the province of Ontario joined Alberta and Manitoba as provinces that have introduced provincial legislation that create punishable offenses, punishable by fines or by jail time, having to do with interfering with critical or essential infrastructure. So for the record, this legislation is in Alberta, the Critical Infrastructure Defense Act of 2020. In Manitoba, the Protection of Critical Infrastructure Act 2001. And in Ontario, the Keeping Ontario Open for Business Act 2002. The details of these provincial level laws are different. They define critical infrastructure in slightly different ways, or they might refer to essential rather than critical infrastructure. But they all make it an offense to interfere, either to enter or to interfere with the operations of critical infrastructure, as they are designated in law. And I think there's reasonable concerns here about the extent to which these provincial level initiatives might encroach on freedoms to assembly and the freedom to protest in Canada, which is an issue that I'd be happy to return to later in our discussion.
Thank you, Professor Boyle. So you've introduced two themes here that we're going to take up in a little bit more detail. And the first is the sort of multi-level governance issues or the federalism challenges that are associated with protecting critical infrastructure. And I know that there is a separate discussion, separate panel, which is going to be devoted to some of the federalism issues, but we will expand on those a bit today. And the second issue is the public-private divide and the fact that
folks, if you want to be kept up to date on what's happening at the Emergency Act Inquiry, including my live tweets and some clips and highlights that occurring at the Emergency Act Inquiry, by heading over to revolutionnews.ca/Emergency Act Commission, that's revolutionnews.ca/Emergency Act Commission. And of course, here folks, while you're there, please head over to donorbox.org/Emergency Act Commission. That's donorbox.org/Emergency Act Commission. And of course, here folks, if you could chip in a buck or two, that will be greatly appreciated, as it will help me cover my travel expenses, including my expenses on food, as bringing you these stories doesn't come for free. Thank you so much.